civil and criminal bill and the sub.
Yes, I would like to offer this Senate committee substitute. And this is what we, last week when I presented that we were also going to add the governor's fentanyl language. That was my, Senate Bill 1368 to this. And so when I presented last week, I presented both of these bills as the sub because we knew that we were going to do the sub. And so this has everything in it as discussed last week. However, the one issue that was raised by prosecutor last week, we did fix that problem where we had said up to, I believe it was 14 milligrams of fentanyl, and so we removed the but less than 14 so that it wouldn't cap it, because the prosecutors were concerned that the way that we had it worded, it would cap it, and then they couldn't prosecute for amounts over that. So that has been fixed, and I'm happy to answer any questions.
Any questions for the bill sponsor? Seeing none, I would now make a motion that we adopt the Senate committee substitute. Do I have a second? Second. It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. You guys have it. You've adopted Senate committee substitute for Senate Bill 1451. Any further discussion before the do pass motion?
Yeah, I got one question. What are
Senator
I
May.
was concerned with the penalties on this. Tell me, can you talk to me about that? So I thought that we did a penalty change a couple of years ago on fentanyl. Am I not correct? When we were in here. And so what we're doing now is increasing the penalty, or
Right, for the amount of milligrams.
so you're lowering the amount of milligrams that's going to be for the penalty. Is that my understanding? I'm trying to get.
Right now, pretty much. Right now, the prosecutors are having trouble with the waiver of fentanyl laws are written.
So didn't we, let's see, in 2000, what is this? In 2020, didn't we do a restriction right here? I think Bob Onder had a bill. Is that right? Where we lowered the amount, and then we added penalties to that amount. So we're restricting it even further, is my understanding. Is that, am I correct in what your bill is doing? That's all I'm asking.
We've changed the milligrams so that the penalty can
Pick up a lower amount. And that's, and,
if someone is caught with a lower amount of fentanyl than what we have in statute now,
okay.
they can be arrested and have the penalty be prosecuted.
Okay.
Sir May, does that answer your questions?
It does. I'm checking something out. And so the penalty is the same? We just lowering them out, but we keeping the same penalty?
So that you can still, so that you can, right, so that having a less amount would still make the charges.
And that's second degree? Okay.
We'll now make a motion that we vote do pass Senate committee substitute for Senate Bill 1451. Do I have a second? It's been moved and seconded. Madam Secretary, please call the roll.
Senator Lukemeyer,
Aye.
Schroer, Coleman, May,
No.
Roberts, Thompson Rehder, Trent.
By your vote of 5-2, you have voted do pass Senate committee substitute for Senate Bill 1451. I'd now make a motion that we exit executive session. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those the contrary, no. We're out of executive session. First bill up is Senator Brown, Senate Bill 1400. Senator, whenever you're ready, if you're in here. Yep, there he is.
Good afternoon. I'd like to thank the committee for the opportunity to present Senate Committee Substitute for Senate Bill 1400. For the record, my name is Ben Brown, State Senator for the 26th District. And this bill pertains to two topics, the unlawful posting of personal information as well as business records entered in as evidence. For the provision addressing unlawful posting of personal information, under current law, a person commits the offense of unlawful posting of information, also commonly referred to as doxing, if they knowingly post the name, home address, social security number, telephone number, or any other personally identifiable information of any person over the internet with the intention to cause great bodily harm or death or threatening to cause harm. Senate Bill 1400 would extend this to individuals that knowingly post a person's personal identifying information to intimidate, harass, or obtain financial gain. And earlier today, actually, I was met with research, and I want to actually, in a sub, tighten the criteria for this new provision a little bit. The aim here is to prevent people from being able to post identifying information that could be then used to run a credit report or something damaging to that effect. And so we want to not leave it as broad to where posting someone's name, someone could claim harassment and utilize it that way. So we plan on tightening that to a certain extent. This would also change the penalty under the current law from a Class C misdemeanor to a Class E felony if a person causes harm or death of another person by posting personal identifying information. For threatening harm or death to a law enforcement officer, judge, or public safety officer, it would change it from a Class E felony to a Class D felony. And if a person causes harm or death to a law enforcement officer, judge, or public safety officer, it would change from a Class D felony to a Class C felony. The second provision addresses business records entered in as evidence. In serious felony cases, police officers oftentimes use electronic evidence, such as information from Facebook, Google, AT&T, and other companies, because many times these platforms are used to openly communicate aspects of criminality. Prosecutors must be able to put the information gathered by detectives in the evidence by either using a business records affidavit, a BRA, from the technology company, or having a live in-person testimony at the trial by a records administrator from the technology company. And there were no issues with the process of just using a BRA until a court ruling by the Missouri Eastern District Court of Appeals in January of this year that said entering a BRA in evidence is not compliant with Missouri statute, even though it is compliant with the requirements in federal court. This ruling means that anytime a prosecutor wants to enter certain technology evidence at trial, they're now forced to actually fly in a custodian of records or a records administrator from companies like Google, Facebook, etc., and they have to be here in Missouri for the duration of the trial. The changes contained in the committee sub would bring Missouri statute in line with the Eastern District Court ruling and would allow business records affidavits to be entered into evidence that contain an electronic signature that is not notarized. Thank you. I'd be happy to answer any questions.
Any questions for the bill sponsor? Seeing none. Thank you. And Senator, I know you do have another committee that you have to go to, so you can feel free to leave whenever you need to. Okay. First witness in support of Senate Bill 1400.
Good afternoon. My name is Andrew Wren. I'm a prosecutor in St. Louis. The issue that has come to our attention and the attention of other prosecutors in the region is this court ruling. We typically make serious felonies such as homicides and other dangerous felonies through these electronic records. I'm going to give you a brief story illustrating what I think is the point. About 2 years ago, I prosecuted a quadruple homicide during which the defendant, he was a clothing thief. He would steal clothes and then sell them on Facebook. He was kicked out of his own house by his mother, and he was graciously brought in by the mother of a friend of his. After several days at this house, he realized that this woman had a lot of expensive clothing herself, and so he decided to take it. Obviously, this woman wouldn't allow it, so he killed the woman, her 8-year-old son, his friend, and another friend who was staying there. So 4 people were killed. That house had an interior door to the garage, so he was able to kind of scoop up all these clothes and some electronics and place them in her car, the homeowner's car, drive away, disappear into the night. Either through skill or through luck, there was no physical evidence at the crime scene. There was no evidence that he was there. It wasn't until several months later that detectives saw him selling some of the clothing on Facebook Marketplace and were able to start their investigation there. They looked at the cell phone records. They looked at his Google search history, which showed that he was Googling the inscription on some medication that he had stolen from one of the victims, and some other searches that were relevant to the homicide. And they were able to start putting together a case on him based on his search history and his cell phone data. They started interviewing people as a result of that. One of these people tipped off the defendant that he was under investigation. He fled to Columbia, Missouri. Those same cell phone records allowed us to track him to Columbia and ultimately apprehend him. At trial, I would estimate that about 90% of the case made against him was based on these electronic records. We were able to obtain these from technology companies, and I was able to put them into evidence using a business records affidavit. Until January of this year, the records affidavits that were provided to us by these technology companies allowed us to put all these records into evidence. They're very, very powerful records. And unfortunately, with this court ruling, it's made it somewhat more difficult for us to do that. Many of these technology companies and their legal teams are reluctant to give us affidavits which they themselves did not create. And so what we're asking for is that the statute be amended to allow us to remove the notary requirement. Otherwise, the alternative at this point is to fly in custodians of records from other states and have them testify as to the authenticity of these business records. The language as presented in this amendment would bring Missouri courts into line with their federal counterparts. So this is already being done in federal courts in Missouri. And other than that, these are records that we use in very, very serious cases, and this would be an excellent tool in our toolbox.
And so you said the way the federal rules of evidence are written right now, that there is no notarization requirement and electronic signatures are accepted in federal court.
Yes, Senator.
Okay. And still, even if we made this change, somebody who submitted a false business records affidavit could still be prosecuted for perjury if they falsified a record.
Yes. So if an attorney knowingly submitted a false record, they would certainly be subject to discipline by the Missouri Supreme Court. I'm more familiar with the criminal side of things. There are numerous safeguards in place in the discovery process put out by our state and federal courts as well as the Missouri Supreme Court, which require all of this to be turned over well in advance of it ever being used in court.
Any further questions for the witness? Seeing none, thank you for your testimony.
Thank you very much.
Do we have any witnesses in opposition today? Just a show of hands, so that way we can go back and forth if we do. Okay, don't see. Further witnesses in support of Senate Bill 1400?
Chairman, members of the committee, thank you. My name is Chris DeSanto with the Missouri Police Chiefs Association and with the Law Enforcement Legislative Coalition. We're responding on record that we support this bill. We appreciate this one of our prosecutors and tools so that we can properly investigate these incidents and to offer some protection for police officers, judges, and prosecutors.
Thank you for your testimony. Any questions for this witness? Seeing none, thank you. Further witnesses in support of Senate Bill 1400? further witnesses in support? Seeing none. Witnesses for informational purposes only? Seeing none. Senator, any concluding remarks?
Just like to once again thank the committee for the opportunity to present.
Thank you. This will conclude the hearing on Senate Bill 1400. Next up is Senate Bill 897. Senator Trent, whenever you're ready.
Thank you, Mr. Chairman, members of the committee. Curtis Trent, representing District 20. This is a bill that contains, and we're talking about the committee substitute here, which I believe everyone has, contains several different provisions, many of which the committee has heard before. So what I'm going to do is just go through and kind of read the headings of each section. If anyone has any specific questions, I'll be happy to answer those. I believe we also have some witnesses here today that can answer detailed questions as well. So the first component is the moratorium on eviction proceedings, which is already passed out of the Senate. That's section 67.137. Next is birth, death, and marriage records. Firefighters Procedural Bill of Rights Act, they're in section 320. The next one is court dissolution of a limited liability company. Alternative dispute resolution process, section 435. The Uniform Child Custody Jurisdiction Enforcement Act, they're in sections 452 and 487. The Uniform Child Abduction Prevention Act in 452. The Uniform Unregulated Child Custody Transfer Act in section 435. Classification of minors for orders of protection, section 455. Qualified spousal trust, 456. Principal place of administration of a trust, section 456 as well. Uniform Electronic Wills and Electronic Estate Planning Documents Act in section 474. The estate planning during COVID-19, section 474 as well. Guardianship and conservatorship, appointment of grandparents and persons acting as parents, section 475 and 488. Mental health treatment courts, section 478. Compensation of jurors, section 488 and 494. St. Louis Circuit Court civil case filing surcharge, 488. Admissibility of statements of children and vulnerable persons in criminal cases, section 491 and 492. Funding of legal actions by foreign individuals and entities, section 507. Uniform Interstate Deposition and Discovery Act, sections 510. Property with collectible judgments filings, section 534. Uniform Public Expression Protection Act, section 537. The Uniform Civil Remedies for Unauthorized Disclosure of Intimate Images Act, sections 537. Information received by probation and parole officers, section 559. Offenses of enticement of a child and offense of patronizing prostitution, section 566 and 567. Offenses involving the judiciary, sections 575. Offenses of tampering with electronic monitoring equipment, 575. Offense of delivery of controlled substance, sections 579. the Crime Victims Compensation Fund modification in Section 595, and funding for the Office of the Public Defender, Section 600. Be happy to answer any questions the committee might have.
Cannot imagine there are going to be any questions, Senator.
And surely
Just-
someone can find one.
Just for the benefit of the committee, Senator Trent has been working with my office on this committee substitute, as well as some of our colleagues over on the House side and the House Judiciary Committee. Many of these provisions were heard by this committee previously this session and voted out, were heard last session and voted out, or are Uniform Act provisions that we feel comfortable with, that we have not yet received the House bill. And so what we're hoping to do is to give the committee a preview of what may be a lot of provisions that end up showing up on the floor, both in a civil omnibus bill or in a criminal omnibus bill. Obviously, we won't be voting on the bill today. We'll be voting on it next week. But that is the purpose of the committee substitute, is to give a little bit of a preview. So I know we've got a lot of information here, but like I said, a lot of it should be familiar to the committee already because it's previously been through this committee. So with that, are there any questions for the bill sponsor?
It will be next week. or before.
No, we will not be execing this week. We will not. We'll exec. The intent will be to exec Monday of next week.
Okay, Monday.
Correct. Yep.
We'll see you on the floor.
Senator Schroer, I look forward to it.
Thank you, Senator. This is a hefty bill. I'm sure some of these portions will probably come out after we get together and try to find a way that this will withstand judicial scrutiny. So I want to ask the question that the senator from Lawrence will typically ask is how do you plan this bill will get past the single subject requirement of the Constitution? Because judicial proceedings is pretty broad.
Well, I mean, do you have any precedent that you're looking at that you think that this bill wouldn't survive judicial scrutiny?
Well, there's a couple of sections in here that could walk a fine line of solely dealing with judicial proceedings. But I think when you take a page and a half to describe all of the sections that this bill modifies, it's going to be a pretty steep uphill battle.
Well, I'm as I've said before, I mean, the courts have, I think, taken a fairly broad view of what a single subject bill is. These are all provisions that relate to the judiciary in, I think, a fairly close manner. I'm happy to have that discussion if you think there is a provision in here that would not fit within the subject of the bill. But I would struggle to lay finger on a provision I think would exceed the boundaries that courts have previously tolerated.
I would agree that the courts have gone back and forth. I mean, you go from the Clay, Missouri precedent from the Supreme Court, where arguably there were several different types of topics, issues that were dealt in. That one, I think, I don't have the case in front of me, but the case from last year in December that the senator from Lawrence has been pointing out when he questions individuals with bills half this size on the floor. So,
I don't believe that the size is actually necessarily what
size doesn't matter.
I think
it's the content of the bill.
Typically, is there a nexus between the various provisions and a articulable goal to be accomplished? And I believe you can find that here, and the court has previously found that in cases that are contemplate bills that are far more expansive than this one.
I want to draw your attention to one that, in going through this morning, I didn't recognize this one. Most of the stuff in here, I either have talked to House members who have this. It's been through this committee. Let me see what page this is on. I think it's on page 99, 507-005. It's the foreign funding, foreign individual, and foreign legal entity. And before I dive into this or let you kind of illustrate where this came from and what problem we're solving here, just drawing down some notes. Some of the notes were answered as I went through this. but you go from 507005 to 510503, both dealing with foreign entities, and it's a little confusing to me. Where you have 507, the funding from a foreign individual or foreign legal entity, and it's defined later in one of the sections herein. But then you jump to 510-503, and it's foreign jurisdiction, foreign subpoena. Basically, foreign could equate to anything outside of Missouri. Is that what the intent is with 507, that any individual, any legal entity formed outside of the state of Missouri, which may have a presence in Germany, Kazakhstan, Canada, would be barred and prohibited from assisting in any type of litigation?
So I believe there's a definition there on page 100. It says, as it's used in this section, a foreign individual is a individual, including an agent of an individual who is not a citizen or national of the United States or any trust, territory, or protectorate of the United States. And a foreign legal entity is any legal entity created under the laws of any government other than the government of the United States or any state or political subdivision of the United States, or any state or territory of the United States, if a majority of the ownership of the stock of such legal entities directly or indirectly owned, legally or beneficially by one or more governments other than the government of the United States or any state or territory of the United States, foreign individuals or legal entities created under the laws of any government other than the government of the United States or any state or territory of the United States, or if a majority of the membership of any such entity is composed of foreign individuals or legal entities created under the laws of a government other than the government of the United States or any state or territory of the United States. Essentially what, and again, I think also if you look elsewhere in the statute, we're talking about third-party entities that are not a direct party to the litigation under consideration. What we're trying to prevent is foreign countries or foreign entities accessing the American judicial system for the explicit purpose of harassing Americans and American companies.
How and I'm going to try to be brief because we can
Sure.
talk more about this offline, but this is one that I'm asking some of the members if they've seen this before. To me, this seems new from the time that we've been in the House and in the Senate, and I don't know how often this is occurring within Missouri.
So this is a bill that I have worked on. I believe is filed this year, perhaps for the first time. At least I'm unaware of prior filings, but I don't think it takes a great degree of imagination to come up with any number of scenarios where it could be financially advantageous to hostile foreign actors to generate the legal fees and the negative publicity that comes with a spurious lawsuit directed at a financial competitor of the legal entities.
I think that you have prongs such as a visa process by which you could, go after some of those entities that are coming after you. So I'll speak to you more offline. I do have some concern over that. Hopefully the courts can remain consistent in what is single subject. But I'm very interested in learning more about that section and how often it is occurring that foreign actors are funding lawsuits that are meritless that continue to go through the process. I think certainly we have the ability to protect our businesses with the statutes that we have in state law and federal law. But yeah, I'll work with you more on that one.
Thank you.
Thank you, Senator.
Any further discussion with the bill sponsor? Seeing none. Witnesses in support.
Thank you, Mr. Chairman, members of the committee. My name is Jason Zamkus. I'm a registered lobbyist appearing before you on behalf of the Missouri Association of Realtors. We'd like to go on record in support of the bill, most notably for its inclusion of the prohibition on local imposition or enforcement of eviction moratoriums. As you all are probably well aware, the governor has wide-ranging powers, emergency powers to control for housing during times of public calamity or natural disaster. And clearly, the decision to impose an eviction moratorium would likely infringe upon constitutionally protected property rights. And for that reason, as an association, we believe that those decisions should be made at the highest levels of government, not piecemeal from one local community to another. And I'd be happy to take any questions.
Questions for Mr. Zamkis? Seeing none?
Thank you.
For testimony. Further witnesses in support?
Mr. Chairman, members of the committee, Ray McCarty, Associated Industries of Missouri. I want to be on record in support of particularly the part on third-party litigation funding. Happy to answer any questions.
Any questions for Mr. McCarty?
A couple questions.
Senator.
So is this, thank you, is this brand new this year? Because I don't recall ever.
I think the idea has been around for a long time. I haven't seen it, I don't believe, before in litigation.
I've seen some of the disclosure, the mandated disclosure,
Right.
which I think that brushed up against some Supreme Court precedents on, is it constitutional, is it unconstitutional? So is this a new approach and has it been tried in other states?
I really couldn't answer that question. I don't know. We don't think, though, it hurts at all to, disclose the fact that there is a third party that's financing the litigation.
But this wouldn't be disclosure, this would be a prohibition, correct?
No, this is disclosure, I believe.
Yeah, the original had the disclosure. The substitute, I believe, has a prohibition. No party, including an intervening party, shall receive funding from a foreign individual or foreign legal entity, which was described further in the bill.
Well, that could be, Senator. I haven't seen the substitute.
Okay. Well, I will, if you have any more information on any states that have tried this, that have actually gone through the judicial process, please forward that to me.
Certainly. Thank you.
Thank you.
Any further questions for Mr. McCarty? Senator May.
Yeah, okay, quickly. So is this broad? Maybe the bill sponsor can answer this. So if someone has a case or whatever in our state against a company or corporation or whatever, is it saying that they can't get, it's only foreign, but they can get funding from out-of-state resources to help with their case, correct?
Yes, I don't believe this would prevent out-of-state funding
Okay.
of the third-party funding. No, we and I read the full description of what a foreign person or foreign legal entity is earlier, and it would appear to me, and I believe the intent is to keep that confined to entities that are constituted under foreign governments.
Okay, thank you.
Any further questions? Seeing none,
Thank
thank you. Further witnesses in support?
Mr. Chair, members of the committee, Heidi Geisbuehler-Sutherland here on behalf of the Missouri Chamber of Commerce and Industry. Similar to the previous witness, we are here in favor of the third-party litigation financing portion, but I have also not seen a copy of the subs, so we are really more in favor of the transparency portion more than the prohibition on foreign funding. But happy to talk with you offline about third-party litigation financing, and the U.S. Chamber also has a lot of information on that as well that I can share.
Any questions for Heidi? Seeing none, thank you for your testimony. Further witnesses in support?
Good afternoon, Mr. Chairman, Senators. My name is Jean Manicki. I'm here testifying on behalf of Missouri Press Association on Senate Bill 897. We also have not seen the substitute, so I'm going only by the original language, and if there's changes, we will want to take a look at them. This bill definitely fits within the judicial proceeding language at the top of the bill, so I don't think there'd be a problem with that. There are 32 other states that have anti-SLAPP provisions in their law, and that's the part of this bill that I wish to talk about. Missouri is in that group of 32, but our anti-SLAPP statute today is very weak, and it needs these improvements that are in this bill. I can go through and tell you that this matches the uniform law. I can talk to you about language if you want to hear that. I'm going to try to keep this short, but it's not just the public that benefits from this. The media, yes, the media benefits from it, but politicians, people who are out advocating for legal changes in laws are going to benefit from this, because being sued in a libel suit is one of the biggest problems for people who speak out about wanting matters of public interest changed. And if you get tied up in one, the cost of litigation, the time that you lose trying to get through the legal process is massive. And this bill allows you an early route to get to summary judgment, to get to a court to throw out a lawsuit if it doesn't have merit. It doesn't change your ability to have a lawsuit that does have merit. But if it has no merit, this gives you an early out, and that's a very important benefit, and we need this in Missouri desperately. There is a House Bill 1886 that parallels this, that is over here in the Senate, has not had a hearing yet. So I'm hoping that at some point those will get together and this bill will move this session.
Any questions for the witness? And just for the record, I do think that the language in the substitute is identical to the filed version
Thank
for
you very
that
much.
particular provision. Further witnesses in support?
Good afternoon. My name is Locke Thompson. I am the Cole County Prosecuting Attorney here on behalf of the Missouri Prosecutors Association. We just wanted to go on the record in support of this bill. It has a number of provisions which not only help us do our job as prosecutors in the courtroom, but also help take care of victims, protect victims, both in the courtroom and financially. So I'm happy to answer any questions.
Any questions for Mr. Thompson? Senator Coleman.
I'm sorry, I zoned out just a minute, Mr. Thompson.
That's fine.
Which sections were you testifying in support of?
Specifically, provisions such as the Crime Victims Compensation Fund,
Okay.
adding Class E felonies to that, probation and parole records, allowing us to do our job a little bit easier, 491, 492 fixes.
Yep. Okay, great, thanks. Just trying to keep
Yep.
track of what
Sure.
specific pieces in this giant bill
It's a
people
big
are in
bill,
favor
yeah.
of.
Any further questions for Mr. Thompson? Seeing none, thank you for your testimony. Further witnesses in support?
Good afternoon, Mr. Chairman and members of the committee. Heath Clarkston, I'm here on behalf of the Missouri Broadcasters Association. I agree with the comments previously from Ms. Manicky with the press. We have a story of a Central Missouri television station I'd love to share with you on this that would make you understand the need for the bill.
Any questions for Heath? Senator Coleman.
Is that story on the record?
I can get it to you for sure.
Thanks.
Yes, it probably would be actually.
Any further questions? Seeing
Thank
none,
you.
for your testimony. Further witnesses in support?
Mr. Chairman, members of the committee, my name is Andy Briscoe. I'm the registered lobbyist for the Missouri Bar. I'd like to thank Senator Trent for bringing this forward. The initial bill contained a number of our provisions that are priority pieces, and we'd like to go on record as supporting the ADR provision, the principal place of administration of a trust, uniform electronic wills, estate planning during COVID, and qualified spousal trusts.
Any questions for Mr. Briscoe? Seeing none, thank you for your testimony. Further witnesses in support?
Good afternoon, Mr. Chairman, members of the committee. My name is Paul Ladehoff. I'm here as co-chair of the Missouri Bar ADR Committee to speak in favor of the ADR provisions in the bill, Senate Bill 897. And mediation has grown exponentially in the 37 years since 435-014 was adjusted to include mediation. It's actually become the major settlement vehicle for parties in dispute. And the procedures and practices in mediation have evolved along that time and adapted to the changing needs of the disputants. So this change to the statute we see as critical to harmonize it with modern trends, and the updates will, they've been vetted fully by mediation providers, mediation users, attorneys over a number of years. This all started with an effort by the Supreme Court. They had an ADR commission that looked at improving Rule 17 of the Supreme Court, and then it became obvious that what we needed to do was look at the underlying bill. And this proposed changes to 435-014 will
reflect those changes that have occurred in practice. They'll meet participant expectations to achieve clarity with some definitions and providing meaning to those terms for consistency. It explains confidentiality and when there might be exceptions, procedures, requirements for mediators, and due process. So to keep it brief, I'll just say I'm happy to answer any questions.
Any questions for Professor Ladahoff? Seeing none, thank you for your testimony. Further witnesses in support?
Good afternoon, Mr. Chairman, members of the committee. For the record, James Harris, registered lobbyist for the Institute for Free Speech. Here to go on record in support of Senate Bill 897, specifically the Uniform Public Expression Act in Section 537 that is based off the model language from the Uniform Law Commission. This is identical wording to what was in conference, well, fell apart, conference on Senate Bill 72 last year, as well as 2022 Senate Bill 968. With that, happy to answer any questions.
Questions for Mr. Harris? Seeing none, thank you for you.
537.
Further witnesses in support?
Mr. Chairman, members of the committee, Eric Jennings, Government Relations Counsel for the Supreme Court, on behalf of the Judicial Conference. You may recall a few of the provisions that Senator Trent mentioned, juror compensation, obviously, which this committee voted out earlier this session. The orders of protection are actually raise the age technical amendments, just to catch up with previous legislation on that. The mental health treatment courts provision he mentioned in the committee sub was from Senator Black earlier this session, Senate Bill 1370, which the committee has voted on. And also the provisions relating to tampering with the judicial officer and judicial proceeding. Senator Trent had filed that as a standalone bill, Senate Bill 1441. That is follow-up on the Judicial Privacy Act from last year. Tampering with a victim or a witness also includes ineligibility for probation, parole, or conditional release. This would merely harmonize that with the two provisions on tampering with the judicial officer or tampering with the judicial proceeding so that those were aligned.
Great. Any questions for Mr. Jennings? Seeing none, thank you for your testimony.
Thank you.
Further witnesses in support?
Chair, members of the committee, Jessica Petrie here with the Missouri Network Against Child Abuse, formerly Missouri Kids First. We want to specifically support the same provision as the prosecutors, the 491 and 492 sections on witness statement admissibility. Raising the age from 14 to 18 is critically important to make sure that we're protecting and providing supports to minors who are going through an incredibly traumatic experience, having these cases of sexual abuse and other issues go to trial. So really appreciate the consideration of including this language.
Thank you. Any questions for Ms. Petrie? Senator Coleman.
Just wanted to see if you all had taken a position on House Bill 2109, guardianship and conservatorship appointments of grandparents and persons acting as parents.
Not to my knowledge, but I can get back to you.
Okay, great. I just haven't heard anybody testify on that piece at all. And then also, when you're checking the uniform language update that is in House Bill 1660, amending the Child Custody Jurisdiction Enforcement Act, as well as the Uniform Child Abduction Prevention Act.
Okay.
Those are new provisions to me as well that I haven't heard anything about.
Absolutely, I can do some checking.
Thank you so much.
Any further questions for Jessica? Seeing none, thank you for your testimony. Further witnesses in support? Any further witnesses in support? Seeing none, any witnesses in opposition?
I don't remember the last time I got the opportunity to come here. Thank you, Mr. Chairman, members of the committee. Jewel Paddock, registered lobbyist on behalf of International Legal Finance Association. In relationship to the two sections, one in the original bill, section 476.413, and in the sub 507 point, I can't even read my own writing, but roughly 055 related to both disclosure of third-party financing as well as the provisions prohibiting foreign financing. Our association is members do provide third-party financing to businesses to fund their business operations during litigation. For that reason, the prohibition as well as the disclosure, we believe, is aimed primarily at crippling a defense or an effort to survive long-lasting litigation and favor one or the other parties. I don't know about what foreign entities do financing in Missouri, but I can say a lot of our businesses in Missouri are foreign. It wouldn't be unlikely for a foreign business located in Missouri to say they're from, I'll just pick a country and try to avoid one that actually is one of our companies, but let's just say I'll pick England. A British company in America, operating in Missouri, finds himself in litigation. They'd reach out to a financial institution in England to help fund that, and I just don't find that all that egregious. In fact, I represented a business for almost 20 years now whose primary financial resources come from the Lloyd's of London, which happens to be one of the largest financiers in the world, and they go to England quarterly to present how their business is doing, et cetera, to their financiers. And so that is how they fund their entire business in Missouri, as well as their other business holdings across America. And I just think we're trying to meddle in litigation to help one side or the other. And I think if there is reason for the courts to be involved in these third-party finance matters, they have the purview and the discretion to do so. Otherwise, and the Missouri legislature should stay out. Be happy to answer any questions.
Any questions for Mr. Paddock? Seeing none.
Thank you, Mr. Chairman.
Thank you for gracing the committee with your presence for the first time this session. Further witnesses in opposition? Seeing none. Any witnesses for informational purposes only? Seeing none. Senator Trent, do you have any concluding remarks?
Just real briefly, I believe the scenario posited by the last witness in opposition would not, in fact, be covered by this bill, but I'm happy to work with anyone who has concerns and try to address those before we get something to be voted out of committee. I appreciate the committee's time and consideration.
That will conclude the hearing on Senate Bill 897. Next up is House Bills 1692 and 1748. Representative Sparks, whenever you're ready.
Mr. Chair, members of the committee. Okay. Mr. Chair, Mr. Vice Chair, members of the committee, Representative Sparks, District 110, and I very much appreciate your time and listening to a lowly House member. When I got to Jefferson City, I thought this is exactly what a hearing room should look like. And then I went to the House hearing rooms, for which some of you are well aware they don't look like this. I very much appreciate your time. And I bring before you today House Bill 1692 and 1748, and a little bit of a unique perspective today for a couple different reasons. My history is in law enforcement over 15 years, and I will keep this as brief as possible for the folks behind me to have their time. But basically, you're going to hear two different provisions within 1692 and 1748. This has been referred to and will be referred to as Valentine's Law, named in honor of Detective Antonio Valentine, who lost his life December 1st, 2021. And he was my friend and he was my colleague. And I was there that day, and you will hear from others that were there that day when he lost his life in the line of duty. So what has happened in both our urban areas and in our rural areas is years ago, law enforcement entered into a social contract. A social contract that essentially said we will no longer chase bad guys because of the risk of bad guys fleeing and crashing into innocent people and innocent people being hurt and killed. And so as a result, we voluntarily instituted very restrictive pursuit policies upon ourselves. We did that at the request of the community, and it's because that's what they wanted, in hopes that folks running away from the police would not do so and more lives and property would be spared. Unfortunately, what we've seen is the exact opposite has occurred, and it has become an epidemic. And so Valentine's Law is in direct response to community stakeholders coming to the police and others who no longer want lives, limb, and property destroyed anymore. And in my area, St. Louis, this occurs every hour on the hour. Suspects running from the police for reasons unknown. And until now, simply running from the police would be a misdemeanor. And so actually tracking suspects down for a misdemeanor, as you all know, with limited resources allocated to our law enforcement agencies, really wasn't worth the time. What this would do would, if a suspect runs from police, it would create the offense of aggravated fleeing, meaning the suspect would have to knowingly know that he's being stopped, he or she is being stopped by the police, and they would actually have to demonstrate behavior of accelerating away from the police officer, and then, for example, driving in oncoming traffic and putting folks, the police officer themselves and the general public, at risk of serious physical injury or death. And that would make that a felony, with a required incarceration time of 1 year. Now, why, you ask, would that be such a big deal? Well, because what you'll hear from officers behind me, and what I used to do for a living every single day, was arrest these people, suspects that would run from the police, and 4 hours later be released, and then be rearrested multiple times, multiple suspects in the same week. And each time they flee from the police at such high speeds, whether the police are behind them or not, driving when buses are letting kids out at 3 o'clock in the afternoon on Jennings Station Road into oncoming traffic, multiple suspects being rearrested in the same week for multiple of the same offense. Well, if they have to sit down for at least a year, then that immediate effect would be to remove them from being able to do that again. And we actually listen to the jail tapes, and we actually interview the suspects once they're caught. And they absolutely know that that's a game changer. They know the jurisdictions that have harsher penalties. They know the jurisdictions that actually have more lax pursuit policies. And so what we would see, we would actually follow them in an undercover capacity or in an airborne unit, and we could actually see that they would drive at extreme speeds when they were in the city of St. Louis or St. Louis County, and then cross over into St. Charles and immediately reduce their speed. Now, mind you, there's no police officer behind them. They would actually reduce their speed to the speed limit, then exit the county back into St. Louis and immediately start driving fast again, because they know they've been conditioned. Their behavior has been conditioned. And this is an attempt to modify that behavior. The other part of 1748 is attempting some clarifying and cleanup language for escaping from custody at the request of the prosecutors. That's language that you all have seen before multiple years, and there's been some cleanup to that and added because the topic is germane. And with that, I'll answer any of your questions.
Any questions for Representative Sparks? Senator Schroer.
Thank you for presenting these bills. Wanted a quick question, and I think I know the answer. I'm trying to gloss over this. This is the House Committee sub. So were there any amendments that were added onto the floor?
Yes, great question. The 10-mile-an-hour rule was added on the floor. I actually thought it was a good amendment, basically to further demonstrate knowingly accelerating away from police, meaning this would not apply to folks that are afraid that the police officer is not legitimate or an actual police officer and they're looking for a place to pull over. This would not apply for folks that are looking for a well-lit parking lot and continue driving the speed limit and to find somewhere to pull over, or even to find a police precinct to pull over. Not applied. This is only somebody that knowingly accelerates aggressively away from the police and drives into oncoming traffic and demonstrates a risk for serious physical injury or death.
What was the total vote count? Because it was fairly bipartisan.
Yeah, thank you for bringing that up. This not only was filed by both Democrats and Republicans, it was also voted out of committee unanimously and received bipartisan support on the floor.
Thank you.
It's already passed the Senate with bipartisan support, too. Sitting over the House. Any further questions for the representative? Senator Colm.
I was going to just say to the chairman, I apologize. I need to chair a committee upstairs, so I'm going to be excusing myself. Thank you.
Witnesses in support of House Bills 1692 and 1748.
I appreciate your time here to talk about this very important bill. I do not want to belabor your time. I know we're busy. We're in crunch time for the session, and I think Representative Sparks here did an amazing job setting this up. So I want to start by saying, start at the very beginning here. We weren't going to put our brother Tony Valentine's name on a bill that wasn't good, and we weren't going to put him on a bill that was partisan, and we weren't going to put him on a bill that didn't have former judges and attorneys and members of the clergy and members of the African American community and members of the rural Missouri community. Bring people together and say, look, what do we need to do here to get something done about this? Lieutenant Colonel Jason Law of the County Police is going to speak here shortly. He'll give you some facts and data and statistics on the epidemic this is. But I mean, we're having thousands of these cars flee every year. And like Representative Sparks said, sometimes it's for no good reason. They just have bad plates, or maybe they got a kind of a Mickey Mouse warrant of some kind. It's not worth it. Now, in the case of Detective Valentine, our brother Tony, he was attempting to apprehend a very violent felon. And that violent felon crossed over the center line on a 35-mile-an-hour surface street in North St. Louis County. And when our investigators did the investigation and pulled the black box, for lack of a better term, from the suspect's vehicle, he was in excess of 90 miles an hour a couple seconds before the impact. The only reason I don't have two dead friends right now is because the second detective in the back of the van, his body was stopped from going out the windshield by a computer that he was using. It was on a mounted rack. So we could have two dead policemen we'd be naming this bill after, but by God's grace, we only have one. We have to get the word out to these guys that this behavior is not going to be tolerated. With that being said, I also agree with Representative Sparks' sentiments is that we should have restricted our pursuit policies. It's not 1970 in St. Louis County anymore. We're an urban county in most parts of it. So I think we need to show some restraint, and we need to save those police pursuits for people that are truly a danger to society. So we've done our part, but the suspects have taken advantage of that. The word's out. You can go on Facebook or TikTok or Instagram, and they brag about it. I mean, they joke around even giving lessons on how to high-speed the police. If you call them up, you can pay them. You got to bring your own stolen car, though. And I've seen that. I mean, that's not a joke. They're doing that seriously. So I'll say in closing is that a mentor of mine when I was really young always told me, he's like, Joe, when you're trying to convince somebody of something, you have a position of support or opposition to a matter, you can't fully understand and articulate your position unless you know what the other side thinks about this. And that was why it was important for us to be a bipartisan effort. And I can tell you what most people are going to say. I don't want my daughter driving home from her job at Quick Trip at 11 o'clock at night and see a car she's not positive it's marked or not, and she doesn't feel safe. So she drives an extra mile to the nearest Quick Trip that she knows is going to be well lit and pulls over there. And then now all of a sudden you're going to charge her with a felony. This legislation makes that completely impossible. A policeman can arrest you for anything. If they want to free case him an aggravated fleeing, I mean, there's nothing any of us can do about that, but the prosecutor could not charge the crime. As a matter of fact, you'd be violating their civil rights in many ways on that one. So, there's no perfect piece of legislation, but we spent a lot of time and effort listening to just a myriad of people across the political spectrum. And it's no surprise this has had bipartisan support. It's a nonpartisan issue in our opinion. So on behalf of the 900 members of the St. Louis County Police Association, and my brothers that are in this room today, I really encourage you to support Representative Sparks' bill, and I'll stand for any questions.
Any questions for the witness, Senator Sharp?
Yeah, I wanted to thank you guys again. I mean, before you said it, I was going to thank you for all the work you and the men and women behind you have put in past couple of years on this bill. It's been very important. I think this is a incredible bill to honor Valentine, to make sure that that incident doesn't happen again. And I also want to thank both of you guys for acknowledging the vice chair finally in this committee. God bless you.
You're welcome, Senator.
We're never going to live that down, by the way. Any further questions for this witness? Seeing none, thank you for your testimony. Further witnesses in support?
Good afternoon, committee, Mr. Chair and Vice Chair. I think there you go, twice. My name is Jason Law. I'm a Lieutenant Colonel with the St. Louis County Police Department. And I'm going to talk to you just briefly about some of the stats, then tell you a little bit about Tony and see if you have any questions for me. Tony was part of a group called our Violent Crime Initiative, or the Street Team. And since 2021, they've spiked 819 cars that fled from them. And this is a group of about 10 guys that go out and are deployed in high crime areas. Of those, there was 304 federal cases made, 1,257 arrests, 979 guns taken off the street, plus a bunch of methamphetamines, cocaine, fentanyl, and about $1 million in currency. So that's just 10 folks in St. Louis County. St. Louis County is a large county. We had roughly 3,000 cars that fled from our Division of Patrol just last year. That's a lot of cars. Those are cars that go on to flee, and they hurt people, not just policemen, just not Detective Tony Antonio Valentine, but just normal everyday citizens just going to the grocery store, going to school, or wherever they might be going. Something like this law will give us the leverage and the tools to help us make sure that the public, once educated, understands that you're going to go to jail for a year. And that just that education alone will be a deterrent. Just not the fact that we're going to pursue more cars, it's the deterrent the law is there, and that the prosecutor is going to prosecute it. So, you know, for us, it would give us some support as well with the police officers. They believe they need more tools and more support out of the state of Missouri, and this would definitely go a long way with supporting the police. Tony was a great guy. He worked for me for several years. He was part of the Violent Crime Initiative. He was also part of many of my units throughout my career. He was also in the military, and just a fantastic person, and continued to serve. And he served his country well, and he served the citizens of St. Louis County and the entire region of St. Louis. Tony's son, Jalen, is in the academy. This law would probably help protect him as well. He graduates from the police academy in July. So, you know, these are things that are important. I think would be important to his son. Several of the officers here, we all watched Tony die in the emergency room at Barnes. You know, it's something that's extremely difficult for Justin and the gentleman sitting right behind me. So we'd love your support. Thank you for hearing us speak today. And if you have any questions about stats or anything like that.
Thank you for being here, and thank you for your testimony and for sharing that personal side of the story as well for the bill's naming. Any questions for the witness? Seeing none, thank you for your testimony.
Thank you.
Further witnesses in support?
Thank you, Mr. Chairman, Mr. Vice Chairman, members of the committee. Again, my name is Christy Giuseppe. I'm a police chief. I'm here with the Law Enforcement Legislative Coalition and the Missouri Police Chiefs Association. And we just want to say that we stand with St. Louis County Police Department and all of the law enforcement that put this together. We appreciate it. Just so you know, we are in St. Charles County. We have this problem also. We have a criminal interdiction task force that we run out there. And each night that we conduct operations, we have between 2 and 6 people that flee from the police, high rates of speed, and so forth. And we need this deterrent. So please give this the utmost consideration, and we thank you for your time.
Senator Schroer.
Thank you, Chief. I've been on a couple of those task forces, and for the members on the committee and people in the audience that aren't familiar with the utilization of drones, can you explain a little bit how these drones, when somebody's going at a very high rate of speed, how you can utilize those drones instead of having an officer following them at 110 miles an hour. And this technology with the drones and some of the license plate readers that can track these people down and identify who it is. So when they think they're escaping, the prosecutors can come in and do the job.
Yeah, absolutely. And we've utilized technology to try to keep these pursuits safer. And that is one of the things that we use, either drone or we have air support. They can track the vehicles. License plate readers give us a heads up as far as stolen vehicles that are coming by or felony warrants and such. And it's been a good tool. And luckily, we've avoided a lot of serious accidents and crashes. So technology and good policy are what we need. It's not, we don't need to completely stop chasing everybody. We tried to do that, right? It just doesn't work. If we get too passive on it, we need to have some type of deterrent. That's why this law is so essential for our success. So,
any further questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support, House Bills 1692 and 1748.
Thank you, Mr. Chairman, members of the committee. Sean Rhodes, registered lobbyist for Missouri Sheriffs United. Okay. Just going on record in support. Would like to answer any questions if we could.
Any questions from the Vice Chairman?
Not for this guy.
Okay.
Seeing no other questions.
Thank you, Mr. Chairman.
Sean, thank you for your testimony.
Thank you.
Further witnesses in support.
Good afternoon again. Locke Thompson with the Missouri Prosecutors Association. Just wanted to go on the record in support of this bill and say that it's not just something that you see in the highly populated urban areas. Here, even in Jeff City, we deal with chases and high-speed pursuits far too often than we should. So I think this bill is a great step toward deterring that behavior.
Any questions for Mr. Thompson? Seeing none, thank you for your testimony. Further witnesses in support.
Yeah, his pursuits come to my county. Good afternoon. I'm Sheriff Bonham, Osage County Sheriff, just across the river. I did want to come in support of this bill. And first of all, condolences to my brother officers on your loss. It's tragic, and it doesn't have to happen. I support this bill. We had a recent pursuit of a felon that stolen a car out of Independence, Missouri, went to Rolla, was pursued into Marys County, and secondly into my county. We set up spike strips. He avoided the spike strips, turned around and went south. Tried to make contact with several of the law enforcement vehicles. Finally was spiked, which I got spiked too, and was out of commission. And they ended up using a TVI. And at the end of the pursuit, he thought it was all fun. He said, "I hope you enjoyed the ride," because he knew that if the consequences were literally none, but put multiple different officers, including the Highway Patrol, city officers, county officers, across 3 different jurisdictions, which is ridiculous. And if there would have been a felony penalty, he probably would not have continued on because he was looking at consequences for the stolen car, but the pursuit was nothing to him. He thought it was a great game. I'll take questions if you have them.
Thank you, Sheriff. Any questions for the witness? Seeing none, thank you for your testimony.
Vice Chair, I like it.
Further witnesses. Further witnesses in support. Bruns, you know what to do.
Yeah. Mr. Chairman and Vice Chairman, members of the committee. Mark Bruns on behalf of the Missouri FOP, Kansas City FOP, and St. Louis Police Officers Association. Just want to go on record in support of our brothers and sisters in the county. I appreciate Representative Sparks sponsoring this bill and urge you to pass it. Thank you.
Any questions for Mark? Seeing none, thank you for your testimony. Further witnesses in support.
Jessica Petrie here on behalf of St. Louis County. We also want to echo the comments of previous witnesses and go on record in support.
Any questions for Jessica? Seeing none, thank you for your testimony. Further witnesses in support.
Sorry about that. Good afternoon, committee, chair, vice chair. My name is Linnell Anderson. I'm a St. Louis County police officer. I was recently promoted to a sergeant. I've been with the county for about 17 years. Most of my time I've spent in the drug enforcement unit. I was a part of the street enforcement team. It was run by my boss here over my shoulder to my left. I don't really have a lot of technical knowledge. Just want to speak about Antonio. Every time I come up here, I'm like, I'm not going to do this. But so I got to train Antonio and ride with him every day. And I just want to say a few things about him just to make sure you understand what kind of guy he was. As the colonel said, man, the guy was very quiet, but tenacious when he believed in something. Just a solid guy all the way around. When he could have took his time away from serving people, he did his 21 years in the military. He decided to come back and serve the county. So rode with Antonio for a couple years in our unit. It's a very dangerous, dynamic, fluid environment. So you learn a lot about people right away. And, you know, this bill is great. I mean, Antonio would be not happy about his name being thrown around because he was just a modest guy. But the substance contained within, he would be very proud of. So we're out there doing this every day. And since Lieutenant Avery has been promoted, I took over as a supervisor of our unit. So we have to go out there, we have to do this job. And it's a very dangerous environment. So we're not looking to encounter the same people in the same week after we risked it all to catch them, to take care of people who don't know what's coming to them. So, yeah, I just wanted to go on record, not only in support of the bill, but also just tell you guys a little bit about my friend. So, if you got any questions, I'll take them.
Thank you for being here, and thank you for your testimony. Any questions for the witness? Senator Schroer.
Sergeant, I want to say congratulations, first off, and you did a phenomenal job last time. I know a lot of people that were in the committee during that day, they loved your testimony. Said it really got them, answered all the questions, but got them fully in support of this bill. So I think Valentine would be very proud of you for all the work that you're putting in and serving our community.
Yep, thank you.
Thank you.
I just, one more thing, and I want to tell Representative Sparks, who's also one of our brothers, I know what he did that day for Antonio to get him out of there, and so we all appreciate it. And he's had to deal with his fair share of, you know, burying family members who are policemen, so we appreciate it, Justin. Yep. All right, thank you.
Senator May.
Just want to say thank you for your courage, for all of you.
Yes, ma'am, thank you.
Thank you for, serving. It might not seem like it, but we appreciate it.
Oh, we appreciate it, and
Yeah, when
it's
we
easy
call
to do.
911, we appreciate you showing up.
Yes, ma'am. It's easy to do with good people, so got a lot of them in this room, so thank you.
Thank you. Further witnesses in support? Seeing none, any witnesses in opposition? Seeing none, any witnesses for informational purposes only?
Mr. Chairman, Mr. Vice Chairman, members of the committee. My name is Dave Sokoloff with the here from the Missouri Office of Prosecution Services, Missouri Association of Prosecuting Attorneys. Just want to address, well, first of all, you've heard a lot about the provisions of Valentine's Law. I just want to talk briefly about the the provisions of the rest of the bill that consolidates resisting arrest and the escape from custody. Basically, in the past, there's been issues. There's a very fine legal line between when custody is achieved and the difference between somebody resisting arrest and somebody escaping or attempting to escape from custody. Problem is that if the prosecutor guesses wrong as far as what the stage of law that occurs at in making the election and charging that, and the court decides that issue differently, then the prosecutor's out of luck, and the defendant walks free because the court has said, "Oh, well, we think that the person was in custody, not just being detained or under arrest." So what this does is it consolidates the two separate offenses into a single offense. I think most of you all have actually seen this before. This is, I think, about the third year that we're working on this, and we're just here to explain that and to answer any questions that you may have.
Any questions for Mr. Sokolov? Seeing none, thank you for your testimony.
Thank you.
Any further witnesses for informational purposes? Seeing none, Representative, any closing remarks?
Thank you very much for your time.
That will conclude the hearing on House Bills 1692 and 1748. No further business coming before the committee. I make a motion that we adjourn. It's been moved and seconded. We're adjourned.